Back in 2005, Senator Hatch wrote an article, and I want to just quote a portion of that and get our first two witnesses' opinion. Maybe the other two are parts of it. And he said in the article, "The Senate exercises its constitutional authority to determine its procedural rules, either implicitly or explicitly. Once a new Congress begins operating under existing rules, implicitly adopts by acquiescence. The Senate explicitly determines its rules by formally amending them, and then the procedure depends on its timing. After Rule 22 has been adopted by acquiescence, it requires 67 votes for cloture on a rules change. Before the Senate adopts Rule 22 by acquiescence, however, ordinary parliamentary rules apply, and a simple majority can invoke cloture and change Senate rules." And then he says in conclusion, "Both conservative and liberal legal scholars agree that a simple majority can change Senate rules at the beginning of a new Congress," end quote. And I'm wondering, Professor Bender and Wawro, do you have an opinion on Senator Hatch? Do you agree with Senator Hatch on that point?
Well, I think the answer comes down to how the Senate itself interprets that power. And as the debates in 1975 played out over whether the Senate is a continuing body or not, we've seen votes both ways, right? We've seen a majority endorse precisely the position of Senator Hatch in 2005, and we've seen perhaps a buyer's remorse stepping back from that once everyone understands the implications of living in a Senate where a majority can do that. It's clearly technically feasible, and it has been politically feasible, but the question is, at any given moment, is the Senate willing to take that vote again?
So basically what you're saying is that it's a constitutional issue, and then the Senate determines constitutional issues.
Well, yes.
The Senate itself, as a body, determines that constitutional issue.
Yes, because the Constitution says the House and Senate shall adopt their own rules.
Yeah, the Article 1, Section 5 of the Constitution says each House may determine the rules of its proceedings, and so it all flows out of that.
Yes, and the question is, how does the Senate at any given time, is a majority willing to endorse that interpretation of the rules?
And there's nothing in the Constitution about a filibuster, the Rule 22 provisions, things like that.
Correct.
Yeah, and please.
I would just say that one of the great dilemmas of democratic institutions is that it's important to have rules that constrain the behavior of individuals who are members of those institutions, but members of those institutions can change their own rules. The Senate did put in its rules a provision that it is a continuing body as part of a compromise precisely over the question of filibuster reform. But the Senate has demonstrated since that time that basically whatever a majority of the Senate at a given time wants to decide its rules are, it can do that. Now, there may be some issues with the parliamentary maneuvering that has to go on and some breaks with Senate tradition, but the Senate has in its power to make the decision itself over what its rules are at any given moment.
By a majority vote.
By a majority vote, simply by the fact that the Senate operates on the basis of precedent, and that the Senate can fill in the gray areas in the rules, ones that are not clearly established in either in the Constitution or in the Senate's rules, that these are what the rules of the Senate are, and all you need is a majority vote to be able to do that.
Yeah. Let me ask you both one additional question on a long-standing constitutional principle, and that principle is that one Congress cannot bind a subsequent Congress, and you know the simple example could be that you do it in terms of rules, or you do it in terms of a piece of legislation, and say in the legislation we pass something this year and say no Congress can change this law unless you have 75 votes. That is a long-standing constitutional principle, is it not?
Well, I'm not a constitutional scholar, so I'll have to.
Okay.
I would probably send that one to Mr.
Well, I want to ask him a different question. I want to ask him a different question, but
I will answer as a political scientist.
Yeah.
The chamber has the right to set its rules. Sometimes rules get entrenched because the rules themselves cause a barrier to changing them. It's not unconstitutional to create a barrier that's very hard to overcome.
Could I answer that?
Yeah.
Because I helped write the Congressional Budget Act of 1974, which binds the Senate in spite of the fact that it is not readopted every Congress. And if your premise is correct, that Congress of 1974 had no right to bind the Congress of today, then the whole reconciliation process is gone.
Well, it's not my premise. It's in Supreme Court cases, repeated over and over and over again. Mr. Bach, do you have an opinion on that?
Well, I wanted to raise.
And please, if any of the things that was said earlier, please go ahead.
There's an interesting and a tricky problem here, which is both a problem of principle and practice. In the House of Representatives, as many of you know, one of the things the House does on the first day of a new Congress is to adopt its rules. But that leaves the question of under what rules does the House debate the resolution to adopt its rules?
Correct.
Now, this is not a problem in current practice because it's all become quite routinized, but there was a day, especially back in the 19th century, when it could go on for days and days as the House tried to elect a speaker, which it would do before adopting its rules. As I recall, the precedents of the House try to deal with this by saying, well, the House is then governed by general parliamentary law, just as Senator Hatch referred to ordinary parliamentary rules. Well, I would really enjoy finding the book which tells me what general parliamentary law is or what the ordinary parliamentary rules are. Robert's rules, Mason's rules, whose rules? So you run into a logical problem of how are you going to conduct the deliberations over what the rules of the House or the Senate will be if they're adopted anew at the beginning of a Congress.
They don't seem to have much problem in the House.